The tort of intentional infliction of emotional distress, or IIED, requires the plaintiff to prove that the defendant intentionally or recklessly engaged in extreme and outrageous conduct that caused the plaintiff severe emotional distress. But what if an insurer refuses to pay out of a life insurance policy in bad faith? Could this be extreme and outrageous conduct? The Seventh Circuit considered this question in Eckenrode v. Life of America Insurance Company. In September of 1967, Life of America Insurance Company issued a life insurance policy to Katherine Eckenrode's husband. Under the policy, Life of America agreed to pay Eckenrode, as the named beneficiary, $5,000 immediately upon proof of her husband's death by accidental causes. In December of 1967, Eckenrode's husband tragically died after being the accidental victim of a homicide, which left Eckenrode with several children and no assets. Following her husband's death, Eckenrode repeatedly demanded payment under the policy, but Life of America refused. These refusals happened even though Eckenrode met the policy's requirements, and Life of America had no basis for doubting the validity of her claim. Consequently, Eckenrode couldn't afford to cover funeral expenses and had to borrow money. In January of 1968, Life of America sent Eckenrode a letter, implying that payment under the policy was contingent upon the completion of an ongoing police investigation. Further, to get Eckenrode to settle for less than the face value of the policy, Life of America advised that if she didn't accept the amount offered, she'd have to sue for payment. Subsequently, Eckenrode sued Life of America for IIED in the United States District Court for the Northern District of Illinois, based on diversity jurisdiction. In response, Life of America moved to dismiss the complaint for failure to state a claim, which the court granted. Eckenrode appealed to the United States Court of Appeals for the Seventh Circuit.